The $1 million text message. I had a case where I was representing a client who'd gotten into a business deal with an ex-girlfriend. She had provided $250,000, $250,000 into a real estate investment. And the whole dispute was over my client had signed a loan agreement saying he would repay the $250,000 plus interest, plus attorney's fees if anything happened. And unfortunately, the deal went south and everybody lost their money. They ended up breaking up, not as a result of the deal, but they had other issues and they ended up breaking up, and the girlfriend said that she wanted all of her money back. My client said that that wasn't actually the agreement. The agreement was that she had invested in this property and she had agreed if she lost her money that that would be it, but she still forced him to sign this loan agreement. Fast forward to a few years into litigation, my office came in during the last 6 months because the trial was coming up. The client really wanted great representation, creative representation for trial. Just a few days before trial, opposing counsel and I are talking about trying to get the case resolved. And I told opposing counsel, look, I don't think that this case is going to be resolvable because you all think this is a $1 million case, and the most my client is willing to pay is just under $50,000. So ultimately, the other side over text messages initially agreed. He said, look, we have a deal. We were set to start trial on Monday morning. After that, what happened is his client ended up seeing videos of my client living a pretty lavish lifestyle. It involved a nightclub, bottle service. She started to wonder why she was accepting such a low settlement if he still had money. So the other side tried to back out of the agreement. Opposing counsel said, look, we have no deal. We're gonna need to go to trial on this and we'll see how this shakes out. And I told him, look, we already have a deal. We already settled this case. He tells me, Parag, in my decades of practice, this may be one of the dumbest arguments I've heard. If you bring this up to the judge, I'm gonna ask the judge to sanction you, and I think he will sanction you because this argument is absolutely ridiculous that you think that a text message from me to you without any settlement agreement being drafted, let alone ever being signed by the clients, would somehow be binding on our clients. And I told him with a straight face, it is binding, and if you bring this motion, we'll see what happens. So ultimately, we ended up going to the judge to see if a text message was in fact binding as a settlement agreement. And the judge, who was sitting on the bench for decades, Harvard educated, very smart, agreed with me. He said that the text message was a binding settlement agreement, and under the Code of Civil Procedure that had been amended, the lawyer is allowed to sign or enter into an agreement on behalf of the client. And my argument was the text message from him is sufficient that I know that he's making representations for his client to get into a binding settlement agreement. So ultimately, my client paid less than $50,000 to get this $1 million+ case settled, and he was thrilled. If you're looking for creative representation that looks at the case holistically, is willing to work with you and come up with some creative legal strategies, reach out to me and my firm because we're happy to help you.